Hong Kong Stock Exchange Directors Training. Responsibilities of directors of companies listed on the main board of the Hong Kong Stock Exchange. 18. The Corporate Governance Code. The Corporate Governance Code, the Code, is set out in Appendix 14 of the main board rules. It contains two tiers of recommended practices. The first tier contains the Code provisions, which are the minimum standard with which listed companies are expected to comply. Compliance is not, however, mandatory. Instead, the Code adopts a comply or explain approach. This means that companies must state in their half-year and annual reports whether they have complied with the Code provisions. If they have chosen to deviate from the Code provisions, considered reasons for each deviation must be stated. The Code allows listed companies to adopt their own codes on corporate governance practices on such terms as they consider appropriate. They must, however, disclose and give considered reasons for any deviation from the Code provisions as set out in the listing rules. The second tier of recommended practices consists of recommended best practices, which listed companies are encouraged to adopt. Listed companies are encouraged but are not required to include a statement as to compliance with the recommended best practices and considered reasons for any deviations from them in their financial reports. The Code covers 5 principal areas: directors, remuneration of directors and senior management, accountability and audit, delegation by the board, and communication with shareholders. Code provisions. The Code provisions in relation to directors include the following. 1. Full board meetings should be held at least 4 times a year at approximately quarterly intervals. 2. Different people should perform the roles of chairman and chief executive. 3. All directors should be subject to retirement by rotation once every 3 years. And 4. The directors should conduct an annual review of the internal control of the issuer and its subsidiaries. 5. Directors should provide records of training they received to the issuer. 6. Issuers should arrange appropriate insurance covers for directors. 7. In the circular to shareholders and/or explanatory statement accompanying the notice of the relevant general meeting, where the board proposes to nominating an individual for election as an independent non-executive director at the general meeting, issuers should state the process used for identifying the proposed independent non-executive director, why the board believes the proposed independent non-executive director should be elected, the reasons why the board considers the proposed independent non-executive director to be independent, the perspectives, skills, and experience of the proposed independent non-executive director can bring to the board, and how the proposed independent non-executive director contributes to diversity of the board. If the proposed independent non-executive director will be holding his 7th or more listed company directorship, such statement should include why the board believes the individual would still be able to devote sufficient time to the board. Shareholders should vote on a separate resolution to retain an independent non-executive director who has served on the board for more than 9 years. 8. An audit committee should meet the external auditor at least twice a year, and an audit committee's terms of reference should include arrangements for employees to raise concerns about financial reporting improprieties. 9. Non-executive directors, including independent non-executive directors, should attend board, committee and general meetings and contribute to the issuer's strategy and policies. 10. The chairman should at least annually hold meetings with the independent non-executive directors without the presence of the other directors. And 11. Management should provide monthly updates of the issuer's performance, position, and prospect to board members, sufficient to enable them to discharge their duties. The Corporate Governance Report. Listed issuers are required to include a corporate governance report prepared by the board in their annual reports and any summary financial report. The Corporate Governance Report must include certain mandatory disclosures, which are set out in paragraphs G to Q of Appendix 14 to the Listing Rules. Failure to include any of the mandatory disclosures is regarded as a breach of the listing rules. The mandatory disclosures relate to corporate governance practices, director securities, transactions, the board of directors, the chairman and chief executive, non-executive directors, board committees, auditor's remuneration, the company secretary, shareholders' rights, and significant changes to the issuer's constitutional documents during the year.